Hey family, what up, what up, what up? Welcome back to Lonnie B Law, where we are diving into business law, the legal, ethical, and international environment by Professor Henry R. Cheeseman. We are in Unit 1, which is dealing with the legal environment of business. And today we're going to deep dive into Chapter 2, the judicial systems of the United States and other countries. So let's get to it. All right, our outline for Chapter 2. Chapter objectives. After studying this chapter, we should be able to, number 1, describe the development of the U.S. legal system. Number 2, describe other countries' legal systems. 3, list and describe the sources of law in the United States. Number 4, define the doctrine of stare decisis. 5, describe the federal court system. 6, describe the state court systems. 7, describe the jurisdiction of federal and state courts. 8, explain how justice is chosen for the United States Supreme Court or the U.S. Supreme Court. 9, describe how cases are heard by the U.S. Supreme Court. Isn't it interesting how sometimes the U.S. is used and other times the United States? Is it the same thing? Is the U.S. just an abbreviation for United States, or are they really two separate entities? Question. All right. Chapter contents. History of American law, international law, legal systems of the world, sources of law in the United States, the federal court system, contemporary legal issue, the process of choosing a Supreme Court justice. Is this what our forefathers intended? And lastly, the state court systems. And there will be an international law section dealing with, is it really law? Our quote for today: under our constitutional system, courts stand against any winds that blow as havens of refuge for those who might otherwise suffer because they are helpless, weak, outnumbered, or because they are non-conforming victims of prejudice and public excitement. One more time. Under our constitutional system, courts stand against any winds that blow as havens of refuge for those who might otherwise suffer because they are helpless, weak, outnumbered, or because they are non-conforming victims of prejudice and public excitement. And that came from Justice Black in Chambers versus Florida. So what do y'all think about that quote? To me, it kind of makes me think of the big bad wolf in the Three Little Pigs. So that big bad wolf, I wonder if that possibly represents the corporations that we go up against, or maybe people of power, versus, the little people, the so-called little people, because, as we study, we're going to realize how much we, the people, have the power. We just have to be informed. Anyway, let's keep going. All right, we're on page 19. And again, I have the first edition of this book. So if you're following along, your edition might be a different page number, might be slightly different. I don't know exactly what the changes are, but let's just work with what we got, okay? Although the law in this country is primarily based on English law, it is also influenced by other legal systems. Today, there are two major court systems in the United States. The first is the federal court system, and the second is the court system of the 50 states and the District of Columbia. These court systems have jurisdiction to hear different types of lawsuits. So remember, the federal court system hears one type of case, one type of suit, and the court systems of each of the 50 states and the District of Columbia Here's other types of lawsuits. This chapter discusses the history and sources of American law, the various court systems, and the jurisdiction of courts to hear and decide cases. So, if you are planning to sue someone, it is important to know who has jurisdiction so that you bring your case before the right court and you're not wasting your time and or your money. All right. History of American law. When the American colonies were first settled, the English system of common law was generally adopted as the system of jurisprudence. Remember, we talked about jurisprudence in chapter 1, which is the science or philosophy of law. This was the foundation from which American judges developed a common law in America. The following materials describe the English legal system. English common law. English common law was law developed by judges who issued their opinions when deciding a case. The principles announced in these cases became precedent for later judges deciding similar cases. The English common law can be divided into cases decided by the law courts, equity courts, and merchant courts. Law courts. Prior to the Norman conquest of England in 1066, each locality in England was subject to local laws as established by the lord or chieftain in control of the local area. There was no countrywide system of law. After 1066, William the Conqueror and his successors to the throne of England began to replace the various local laws with one uniform system of law. To accomplish this, the king or queen appointed his or her followers as judges in all local areas to administer the law in a uniform manner. The court that developed and administered these rules was called the law court. Law at this time tended to emphasize form, legal procedure, over the substance or merits of the case. The only relief available at law was an award of money damages. Chancery or equity courts. Because of the unfair results and the limited remedy equals legal reparation, available in the law courts, a second set of courts, the Court of Chancery or Equity Court, was established. Equity means quality of being fair and impartial. These courts were under the authority of the Lord Chancellor. Persons who believed that the decision of the law court was unfair or that the law court could not grant an appropriate remedy to seek relief in the Court of Chancery. The Chancery Court inquired into the merits of a case rather than emphasizing legal procedure. And merits are the intrinsic rights and wrongs of a case. Intrinsic means belonging naturally or essential. The chancellor's remedies were called equitable remedies because they were shaped to fit each situation. For example, if a neighbor was polluting a neighboring farm with smoke from a fire, the injured party could seek an injunction from the chancellor ordering the wrongdoer to extinguish the fire. Equitable orders and remedies of the Court of Chancery took precedent over the legal decisions and remedies of the law courts. Again, equitable orders and remedies of the Court of Chancery took precedent over the legal decisions and remedies of the law courts. Merchant courts. As trade developed in the Middle Ages, the merchants who traveled about England and Europe developed certain rules to solve their commercial disputes. These rules, known as law of merchants or the law merchant, were based upon common trade practices and usage. Eventually, a separate set of courts was was established to administer these rules. This court was called the Merchant Court. In the early 1900s, the Merchant Court was absorbed into the regular law court system of England. So, is that the beginning of maritime law? Anybody know? Adoption of English common law in the United States and other countries. All the states except Louisiana base their legal systems primarily on the English common law. Because of its French heritage, Louisiana bases its law on the Civil Code. Elements of California and Texas law, as well as law of other southwestern states, are rooted in civil law. In the United States, the law, equity, and merchant courts have been merged. Thus, most U.S. courts permit the aggrieved party to seek both law and equitable orders and remedies. Thus, most U.S. courts permit the aggrieved party to seek both law and equitable orders and remedies. So that is something to keep in mind if you are going to court. You want to ask for everything you want and need to resolve your situation. All right, do y'all want to read this international law? I'm going to go ahead and read it today, and y'all can give me feedback on whether or not this is something you would like to skip over. Excuse me for bumping my camera. All right. Legal systems of the world. Several other major legal systems developed in the world in addition to the Anglo-American common law system. These are the Romano-Germanic, Sino-Soviet, Hindu, and Islamic legal systems. Other minor forms of law also developed, including tribal laws in Africa and hybrid systems. The major legal systems of the world are discussed in the following paragraphs. And please excuse me for mispronouncing any words. Again, I am no expert. I'm learning right along with y'all. Romano-Germanic civil law systems. The Romano-Germanic civil law system, which is commonly called the civil law, dates to 450 BCE, when Rome adopted the 12 Tables, a code of laws applicable to the Romans. A compilation of Roman law called the Corpus Juris Civilis, or the body of civil law, was completed in 534. Later, two national codes, the French Civil Code of 1804, or the Napoleonic Code, and the German Civil Code of 1896, became models for countries that adopted civil codes. Statutes are also adopted to expand the civil codes. So that sounds definitely like our code system in the United States. I don't know if you're watching from the U.S. I don't want to assume, but one thing that we're going to see is a lot of commonality regardless of your location. In contrast to the Anglo-American common law, where laws are created by the judicial system as well as by congressional legislation. I can't say that word. It just gives me a struggle. All right, the Civil Code and parliamentary statutes that expand and interpret it are the sole sources of the law in most civil law countries. Thus, the adjudication of a case is simply the application of the code or the statutes to a particular set of facts. In some civil law countries, court decisions do not have the force of law, while in others, only appellate decisions have precedential authority. So that sounds like the law courts that we just read about. Today, Austria, Belgium, Greece, Indochina, Indonesia, Japan, Latin America, the Netherlands, Poland, Portugal, Spain, South Korea, Sub-Saharan Africa, Switzerland, and Turkey follow the civil law. Sino-Soviet Socialist Law System. The youngest of the major legal families is the Sino-Soviet Socialist Law System, which applies to over 50% of the people of the world. The Sino-Soviet theory of law is based on the philosophy of Karl Marx, which advocated the eradication of capitalism and the elimination of the private ownership of property. How y'all feel about that? Because, they've been talking about this Agenda 2030 and, applying, is it the socialist system of credit like China has? How y'all feeling about that? After the creation of the Soviet state following the Russian Revolution of 1917, Lenin replaced the old court system with a system of law meted out by workers, peasants, and the military. This legal nihilism, or absence of law, did not last long. And a formal legal system was restored pursuant to new criminal and civil law codes that promoted the socialist ideal. With its emphasis on codes, the Sino-Soviet legal system is a variant of civil law. Since private property in most respects is not permitted under Soviet law, the legal system is composed mostly of public law. Therefore, property, contract, and business organization law, example, corporation and partnership law, this is prevalent in common law in civil law countries, is not important in Sino-Soviet law. Sino-Soviet public law preserves the authority of the state over property and the means of production. Today, socialist law forms the basis of the legal systems of Angola, Bulgaria, Cambodia, China, Cuba, Czechoslovakia, Ethiopia, Guinea, Guyana, Hungary, Laos, Libya, Mozambique, North Korea, Poland, Romania, Somalia, the Union of Soviet Social Republics. We gotta remember this text is like from the 90s. They're talking about Russia, Vietnam, and Yugoslavia. As member states of the Soviet Union and Eastern Bloc countries adopt free market